Very good evening, all the participants. I think we have already covered Supreme Court and High Court cases. So today we'll be covering NCLT and NCLT. In NCLT also, I think we have covered one case, Varsamna Ispat. So this is the PPT. I hope now it is visible. Is it visible?
Yes, it is visible.
Okay. So Varsamna Ispat we have already covered. Now let us see the next case. Kundan Kher versus Amit Kumar Gupta. So what was the case? So this case is similar to Epic Singapore. So the case here is that whether after approval of the, suppose COC approves the resolution plan and it sends it to the adjudicating authority. So now whether the adjudicating authority has any jurisdiction to entertain or permit the withdrawal application filed by the resolution applicant, because all these cases pertain to the COVID period. Because in COVID period, commercials changed because it took 2 to 3 years for the adjudicating authority to approve the resolution plans. And in the meantime, naturally, commercials changed. So the resolution applicants, they were no more interested in having those plans approved. So they applied for withdrawal of the resolution plan. But now the thing is whether the adjudicating authority can entertain any such applications. This was the issue in Kundan Kher. Similar was the issue in Epic Singapore also. So in this case, the successful resolution applicant, Kundan Kher Products, it appealed to NCLT against the impugned order, rejecting its application for withdrawal of its resolution plan and cancellation, revocation, return, refund of the performance bank guarantee on the ground that there is no legal basis or justification for holding that an application for withdrawal of a resolution plan post approval is not maintainable. So NCLT did not agree. Now they moved to NCLAT. So approved resolution plan had been rendered commercially unviable on account of delay in conclusion of CIRP, and the appellant believed that he could not be prevented from withdrawing the same. So this was the issue. Now, what were the arguments put forth in this case? Sudarshan ji, can you please read for me? Sudarshan ji.
Yes, sir. Yes, sir.
Yes, please. Please read.
From arguments, I will start, sir.
Yes,
Once
yes,
the
yes.
plan has been approved, it becomes binding contract between the parties, and the successful resolution applicant cannot be permitted to withdraw the same, which will have the effect of sending corporate debtor into liquidation. Recent decision of this appellant tribunal in Committee of Creditors of Educaf Solution Limited versus EBIX Singapore PTC Limited Company Appeal AT Insolvency number 203 of 2020. Resolution applicant has accepted the condition of resolution plan. It was not open to it to make a U-turn and wriggle out of the liabilities imposed upon it under the resolution plan approved by the Committee of Creditors. Analysis of decision. Case relied upon is entirely different, as it was violative of section 30 of subsection 2E of IBC code. Hence, entirely different from present facts of the case. Second, the appeal being dismissed on the following grounds. There is no provision in Insolvency Bankruptcy Code and entitling the successful resolution applicant to seek withdrawal after its resolution plan stands approved by the Committee of Creditors with requisite majority. Successful resolution plan incorporates contractual terms binding the resolution applicant, but it is not a contract of personal service which may be legally enforceable. The resolution applicant in such case is stopped from angling out of liabilities incurred under the approved plan, and the principle of estoppels by the conduct would apply to it. Value of assets of the corporate debtor is bound to have depleted because of passage of time consumed in corporate insolvency resolution process, and in the event of successful resolution, applicant being permitted to walk out of with the impunity, the corporate debtor's depleting value would leave all the stakeholders in a state of devastation.
Hmm.
The next step.
So this was the case. So you cannot.
Yes, sir.
Next, Ramesh Kimal versus Siemens Games Renewable Power Private Limited. Yes, please. Please read.
Facts of the case: the applicant was filed on 11th May 2020. Meanwhile, Section 10A inserted wide insolvency bankruptcy code amendment ordinance 2020 published in
Now,
Budget.
before understanding this case, we have to read section 10A. So what section 10A says? Section 10A, if we read, it is for the COVID period. It talks of suspension. So it says, notwithstanding anything contained in section 7, 9 and 10, no application for initiation of CIRP of a CD shall be filed. So the stress is on filing. The stress is not on admission. So it is said the date of filing is important for any default arising on or after 25th March for a period of 6 months or such further period not exceeding 1 year from such date as may be notified in this behalf. So basically it is talking of filing. So date of filing of application is important, not the date of admission. This is one point which we have to remember while reading this case law. Yes, please. Now please read.
Yes, I will start from the issues involved, sir.
Right.
Whether an application for initiation of corporate insolvency resolution process of corporate debtor in respect of default committed before 25th March 2020 for a period before 5th June 2020, that is the date on which amending ordinance came into force in respect of such default, would be maintainable in view of the express bar created by the provision of section 10A.
Actually, as we all know, COVID period, it started from 25th March. But this notification came in June. So, what will be the fate of applications for which default has occurred during this period? This was the issue.
Argument put forth. Section 20A cannot be construct and include applications that had already been filed and were pending before the adjudicating authority. In the explanation to section 10A clarifies that the provisions of section 10A would not apply to any default committed prior to 25th March 2020. Initiation date is different from commencement date of CIRP in respect of debtor. According to Form 5, that is the application to adjudicating authority, as also in Form 3, that is demand notice, the appellant operational creditor has specified 30th April 2020 as the date of default, which clearly goes beyond the cutoff date. Therefore, the adjudicating authority was perfectly justified in rejecting the application under section 9 of IBC at the instance of appellant operational creditor, as the default has occurred after the cutoff date and the bar imposed under section 10A was clearly attracted.
Yes. Next case.
Next case. Union of India versus Vijay Kumar V. Iyer. Issues involved. Whether ownership belongs to the government of India, that is the one. Whether spectrum being under contract can be subject to proceedings under section 18 of the code. Whether the spectrum license is subjected to proceedings under the code and it overrides the provisions contained in the Telegraph Act 1885, the Wireless Telegraph Act 1933, and the Telecom Regulatory Authority of India Act 1997. Next, whether spectrum can be treated as a security interest and what is the mode of its enforcement. Whether as per the revenue sharing regime and the provisions of the Telegraph Act 1885, the dues can be said to be operational dues. Whether natural resources would be available to use without payment of requisite dues, whether such dues can be wiped off by resorting to the proceedings under the code and the comparative dues of the government and secured creditors. Next, analysis and decision. Regarding whether it is an asset of CD, IT is submitted that section 14 of IBC only covers what is not permitted during moratorium and does not provide for what is or what is not an asset of CD. Nature of license. The license agreement is in the nature of contractual arrangement between the central government and the TSP's license. The right to use spectrum is an intangible asset of license and cannot be subjected to insolvency proceeding.
So, we can say licensee. Yes. Yes.
Next, spectrum cannot be treated as a security interest. Tripartite agreement according to priority and first change to DOT, the spectrum cannot be treated as a security interest by the lender. That part, it being within the domain of licensor to suspend, revoke, or terminate the license agreement, besides being empowered under Section 20A of Indian Telegraph Act 1885 to levy fine for contravention of any condition contained in its license. The security interest, if any, in the hands of lenders would be so fragile and vulnerable that would seriously jeopardize its enforcement. In view of these findings, we need not consider the mode of enforcement of security interest. Summary of the conclusion. Spectrum is a natural resource and the government is holding the same as statutory trust. Spectrum being intangible asset of the license TSPs telecom companies corporate debtor can be subjected to insolvency liquidation proceedings. Dues of central government DOT under the license fall within the ambit of operational dues under IBC. Deferred default payment installments of spectrum acquisition costs also fall within the ambit of operational dues under IBC. As per revenue sharing regime and the provisions of Indian Telegraph Act 1885, the nature of the dues payable to licensor continues to be operational dues, which are payable primarily in terms of license agreement. Natural resource would not be available to use without payment of requisite dues. Triggering of corporate insolvency resolution proceedings under IBC by the corporate debtor with the object of wiping off such dues not being for insolvency resolution, but with the malicious or fraudulent intention would be impermissible.
Yes, so this was the case. Actually, here, Section 10 application was filed. So, there were various issues that whether this corporate debtor can be allowed to initiate this insolvency process. So, they say you have to pay the dues, operational dues. Yes.
Mohan Gems and Jewels Private Limited versus Vijay Verma and other sir,
Another. What is another? Yes.
Okay. Facts of the case. The application was filed by the liquidator seeking for closure of the liquidation process as per Regulation 45, subsection 3A of IBBA Liquidation Process Regulations 2016. As the corporate debtor being sold as a going concern in the e-auction held on 20th November 2019, declaring Mr. Vijay Verma the first respondent as the highest bidder at a bid price of rupees 4,51,99,713. However, the adjudicating authority ordered to dismiss it. Issues involved: whether the liquidator is authorized to sell corporate debtor as a going concern pursuant to Regulation 32 of IBBI Liquidation Process Regulation 2016, whether adjudicating authority was correct in concluding that Regulation 39C of CIRP Regulation and 32A, 45, subsection 3 of Liquidation Process Regulations are inconsistent with the section 54 of the Code. Whether interpretation by adjudicating authority of the provisions of the code and liquidation process regulations in order to impinge is contrary to the scope and spirit of the IBC. Next, analysis decision. Liquidator can sell the business of the corporate debtor as a going concern. It is seen that the Honorable Apex Court, in a catena of judgments, has time and again observed that liquidation should be the last resort only if the resolution plan submitted is not up to the mark, and even in liquidation, the liquidator can sell the business of the corporate debtor as a going concern. Regulation 32A and 45 subsection 3, which were inserted in liquidation process regulations subsequent to ArcelorMittal India Private Limited, Supra and Swiss Ribbons Private Limited, and another, Supra specifically defined the process of sale of corporate debtor or its business as a going concern. Adjudicating authority crossed its jurisdiction. The sale of corporate debtor company was carried out by the liquidator in accordance with the regulations. However, the adjudicating authority has, apart from traveling beyond its jurisdiction in making observations regarding the power and functions of framing regulations by the IBBI, has also not appreciated the ratio dissolution of the company is to be seen only as a last resort, and every attempt should be made to revive the company and to continue it as a going concern.
So the case here was actually, if you see the amendment, if you particularly read Regulation 45.3, so there was an amendment to Regulation 45.3 in the year 2019. So prior to that, only dissolution was the concept. So they said that the final report shall form part of the application for the dissolution. So, but now there was a change, and they said you can either apply for dissolution or you can apply for closure of the liquidation process. Because if you sell a company as a going concern, then dissolution will not be taking place. So in that situation, the liquidator shall apply for closure of the liquidation process. So this case law is particularly on Regulation 45.3. So they say that even during liquidation, you can sell it as a going concern. This was the case. Yes, please. Please carry on.
Next slide.
Yes, please.
Sir, next slide is not appearing. That is, liquidator has regulator. That is same thing, I think.
नहीं हो रही क्यों?
No,
अजय जी,
no. Oh, अभी एक दोबारा कर लीजिए और एक बार.
This we have already covered. Now,
Now, now it's the same one. Already I read it. Next case. Sir. Next
just a
case.
minute. Let me share it again.
I think we have to see. Now we have to cover sixth one.
Is it visible now?
Yes, yes.
Ajay ji, you can read it.
Okay.
Hmm.
Uh, from the liquidator has rightly followed the procedures. The code has not prevented code has the code does not prevent the closure of liquidation process in the instance of cooperator is sold as a going concern pursuant to regulation 32E following a closure report filed under regulation 45(3) sub-regulation A of the liquidation process regulation. It would be the contradictory to observe that closure of liquidation proceeding cannot be done and only dissolution is provided for under the code. This would demolish the very spirit of the objective of the code. It can be safety. It can
Safely.
be safety.
वो थोड़ा
Safely
सा कई बार गलत लिख दिया होगा. ये सेफली है. It can be safely. Yes.
instructed that before the completion of 270 days, if no decision.
सेफली कंस्ट्रूड हो जाएगा ये एक्चुअली
Yes,
कंस्ट्रक्टेड लिख दिया इसने. कंस्ट्रूड है ये. कंस्ट्रूड. Yes.
Before the completion of 270 days, if no decision under regulation 39C is taken by the COC, only regulation 32 is to be followed.
Yes, please.
Additionally, in instance case, the application under section 33 of the code seeking liquidation was filed prior to 25th July 19, on which date regulation 39C was inserted. Therefore, the question of COC passing any resolution under section 32 process does not arise at all.
So actually, this amendment it took place on 25th July 2019. So they say that either liquidation or closure of the liquidation process both can take place, and it can be sold as a going concern even during liquidation. Yes, please. Next case.
This case is with regards to Jet Aircraft Maintenance Engineers Welfare Association versus Ashish Shacharia, the GT person. And the fact of the case is the applicant was registered trade union representing aircraft maintenance engineering of Jet Airways India Private Limited. I think ये केस हो चुका है पहले, फिर भी पढ़ सकते हैं.
हो चुका है ये.
यस, फिर भी पढ़ लेते हैं एक बार और. अच्छा, इंपॉर्टेंट केस है.
हाँ. तो यहाँ इसको यहाँ से कंक्लूजन पढ़ लीजिए, कोई बात नहीं.
अच्छा कि दिस केस एक बार वो फैक्ट पढ़ लेते हैं सर, फिर.
हाँ, पढ़ लीजिए प्लीज. यस.
The appellant was registered trade union on an application filed by the State Bank of India under Section 7 of the corporate data, the AA initiated corporate CIRP by order 20th June 19. By the same order, moratorium was under Section 14 was declared and consequent direction, respondent number 1 was appointed as IRP. The appellant's claim worth rupees 152.58 crore was admitted by the respondent number 1 and respondent number 2 was constituted as committee of rater. In the third meeting of the COC held on 26th August 19, the RP brought into the notice of the COC that with regards to the aircraft taken on finance lease, a finance up to $25 million is required for settlement with the financial lessors to gain title position of the asset in favor of the company. The COC resolved for raising additional interim finance for specific purpose and for having first charge on the security over the aircraft engines recover in the process. In the HCOC meeting, it deliberated over execution of certain immovable property non-core asset of the corporate debtor. One of the non-core asset identified was BKC building covering 3 floors, second, third and fourth floor encumbered to HDFC Limited. A resolution was passed approving exclusion of immovable property of BKC building as non-core assets, and such asset was not form part of the estate of the corporator to be transferred to a RA. So in this case, in this case underscores the legal principle that statutory dues owed to employees such as provident fund and gratuity are sacrosanct and must be honored in full during insolvency proceedings. The judgment reinforced the protection of employees' right under the insolvency IBC, ensuring that resolution plan do not override statutory obligation. मतलब ये compulsory है ये सब सारे कुछ देखना.
हाँ, जो पीएफ ग्रेचुटी वगैरह, they must be paid in full and they cannot
सारे
be
सिर्फ भैया
compromised in a resolution.
सारे cannot overlook all these concepts.
Right. So here the NCLAT directed the successful resolution applicant to pay the full amount of PF and gratuity dues to employees, emphasizing that these dues are statutory and must be paid in full, irrespective of the resolution plan provisions.
ये सब
So
जगह
this
आते
case
हैं.
went to Supreme Court also. So successful resolution applicant challenged the NCLAT's decision in the Supreme Court, and Supreme Court upheld the NCLAT's ruling, affirming that statutory dues like PF and gratuity must be paid in full and cannot be compromised in a resolution plan. This was the case actually. Yes. Next case.
This case is with regards to State Bank of India versus Mahendra Kumar Jajodia. This application was filed by financial creditors under section 95(1), subsection 1 for initiating IRCRIP against personal guarantor. Okay, this personal guarantor with regards to the against personal guarantor could not be rejected merely on ground that no CRP or liquidation proceedings of principal borrower cooperator was pending before NCLT. The fact is that SBI, the appellant, has filed an application under Section 95 of the IBC for initiating insolvency proceeding against Mahendra Kumar Jajodia, a personal guarantor to the cooperator. The application was filed before the NCLT Kolkata. However, the NCLT dismissed the application on the ground that the application under Section 95 must be filed before the educating authority where the cooperator registered office is located, not where the personal guarantor resides. Okay. Issue whether the application under section 95 of IBC against a personal guarantor can be filed before the NCLT having jurisdiction over the personal guarantor, or whether it must be filed where the cooperator is situated. This is the question. The NCLT overturned the NCLT overturned the NCLT dismissal, holding that the personal guarantor to cooperator cannot be proceeded against under section 95 of the IBC independently. The application can be filed before the NCLT, which has jurisdiction of the personal guarantor residence, not the where the cooperator's office is situated.
Right.
There is no requirement that the application is filed only in jurisdiction of the cooperator. Okay. Legal principle was the NCLT and clarified that personal guarantors are distinct from the cooperator, and proceedings under Part 3 of the IBC can be filed independently. अलग से हो सकता है. The NCLT under the adjudicating authority under IBC for personal guarantor is the NCLT as per the 2019 notification by the central government. The decision broadened the scope for financial creditors to initiate the insolvency proceeding against the personal guarantor at the appropriate NCLT based on the guarantor's location, even if separate from of the cooperator jurisdiction. It reaffirmed the liability of personal guarantors and their independent treatment under the IBC. So ऐसा जरूरी नहीं कि अगर कॉर्पोरेट जो पर्सनल गारंटर का एड्रेस अगर कहीं और है और जो कॉर्पोरेट डेटर है उसका एड्रेस कहीं और है, तो कॉर्पोरेट डेटर का एड्रेस का जो जुरिसडिक्शन NCLT वहीं पे फाइल कर सकते हैं. तो इसमें यही हुआ कि कॉर्पोरेट डेटर जहाँ भी रहता है उस जुरिसडिक्शन में कहीं भी फाइल हो सकता है ये केस.
Yes, please.
So next case is the Technology Development Board versus Mr. Anil Goel and others. The background is the cooperator name is Gujarat Olive Chemical Limited. Applicant was Technology Development Board, a financial creditor with second charge on GOCL assets. Cooperator liquidator was Mr. Anil Goel. Following the failure of the CIRP, the cooperator has entered into the liquidation. The appellant holding a 14.54% voting share in the COC had its claim of 24.78 crores admitted. However, the liquidator distributed the sale proceed exclusively to first charge holder, Asset Stabilization Fund SASF, and Gujarat State Finance Corporation GSFC without allocating any amount to TBD, the appellant actually. The TDB contended that this distribution violates the equitable treatment mandate under Section 53 of the IBC. The argument of liquidator was that while stating that the claim of 24.78 crore was admitted on the basis of the security interest held by the appellant, took the stand that distribution of sale proceeds to the respondent number 2 and 3 being first charge holder was as per para 21 of the IBC Insolvency Law Committee report, and since the appellant only had second charge, no amount was payable from the sale proceed. It was further submitted that the secured creditor relinquished their security interest to the liquidator estate and thus forfeited their right on assets. The only right available to them was to receive proceed from the sale of asset in manner provided in Section 53. It is submitted that the priority of charge, as the first charge on second charge losses its significant on relinquishment of security interest, and the sale proceeds are put in the liquidator, while stating that the claim of 24.78 crore was admitted on the basis of the security interest held by the appellant. The liquidator took the stand that distribution of sale proceed to respondent number 1, respondent number 2 and 3, the first charge holder was as per para 21 of the Insolvency Law Committee report, and since the appellant had only second charge, actually ये repeat हो रहा है actually sir. No amount was payable from the sale proceed. It is further submitted that the second creditor relinquished their security interest to the liquidation estate and thus forfeited their right on the asset. The only right available to them was to receive proceed from the sale of asset in the manner provided under Section 53. ये पूरा line repeat हो गया था.
कोई बात चीज करो. हाँ जी.
It is some argument of the appellant, the financial creditor. It is submitted that the priority of charge, that is first charge or second charge losses, is significant or relinquishment of security interest, and the sale proceeds are put into the common pool of the money to be distributed in accordance with Section 53 of the code, which does not provide for further classification of secured creditors. So when the asset itself is non-existent and rights attached with it are relinquished, there is no question of claim in priority on the basis of being first charge holder. It is further submitted that the first charge holder would have got priority in the event they had not relinquished their right but having relinquished their rights. Section 53 mandating equal ranking among secured creditors would come into play, and the sale proceed have to be distributed equitably among the secured creditors irrespective of their priorities held before such relinquishment. तो उसका argument है I think sir कि once the secured creditors have also relinquished their estate, so
they are all at common platform.
At the same page.
So then there is no question of first charge or second charge. This was the main argument. Yes.
The judgment of NCLAT addressed the issue whether inter se priority among secured creditors should influence the distribution of liquidation proceeds when such creditors have relinquished their security interest. The key findings was equal treatment post relinquishment. The NCLAT held that once the secured creditor relinquished their security interest under Section 52 of the IBC, the rank equally under Section 53, subsection 1, subsection B, subsection 2 of the distribution of liquidation proceeds, regardless of any प्रायर इंटर से प्रायोरिटीज. तो वो भी वही बोल रहा है जो appellant बोल रहा है.
NCLAT ने वही बोला जो टेक्नोलॉजी डेवलपमेंट बोर्ड का आर्गुमेंट.
Right. The tribunal emphasized that the IBC waterfall mechanism overrides any contractual agreement or inter se priorities among secured creditors once they opt to participate in the liquidation estate. मतलब they choose to relinquish their assets.
Right.
So directive to liquidator was that NCLAT directed the liquidator to redistribute the proceed equitably among all secured creditors who had relinquished their security interest, including TDB. ये तो अनिल गोयल सर बोलते नहीं है अपना कभी. अनिल सर अपना वेबिनार लेते हैं बट ये सब बताए नहीं कभी.
Yes.
This case underscores the complexities surrounding the distribution of liquidation proceeds among secured creditors under the IBC. The NCLAT's interruption promotes equitable treatment of secured creditors post relinquishment of security interest, potentially impacting the drafting and enforcement of inter-creditor agreements. However, the Supreme Court stay on NCLAT judgment suggests ongoing deliberation on this critical aspect of insolvency law. कोई
एक्चुअली सुप्रीम कोर्ट ने ना इस पर स्टे लगा दिया.
ओके, अभी भी स्टे ही है.
सुप्रीम कोर्ट ने कहा भाई ठीक है, इसको लार्जर बेंच को डिसाइड करने दो. ये
ओके, तो अनिल अनिल गोयल सर सुप्रीम कोर्ट गए थे चैलेंजिंग द
हाँ, तो
एनक्लेव।
ये जो है, अगर आप इस जजमेंट को भी आप देख सकते हो, ये लास्ट में लिखा ना मैंने, ये दिया है आपको, ये
हम्म।
इस लिंक को भी अगर आप देखोगे तो इसमें भी आप पढ़ सकते हो।
सो राइट नाउ दिस इज अंडर सुप्रीम कोर्ट सर, और
हाँ
डिसीजन
बिल्कुल
हो चुके
बिल्कुल
हैं।
बिल्कुल, यस, नेक्स्ट केस।
Next case is Hindalco Industries Limited versus Hirakund Industrial Works Limited and others.
हम्म,
Applicant is
यहाँ से
Hindalco
पढ़ते हैं
Industries
फैक्ट्स ऑफ द
Limited.
केस।
Loan in default. The Nandakini Contractors Private Limited granted a loan of rupees 14 lakh 51,047 to Hirakund Industrial Works Limited. Due to non-payment, Nandakini filed a Section 7 application under, ये 14 करोड़ होगा सर?
नहीं, पुराना केस है ना,
14
1 लाख वाला
lakhs.
केस है ये।
Okay. Application under the IBC to initiate the CRP against the
पहले तो
Hiran.
1 लाख ही था ना, बाद में 1 करोड़ हुआ ना।
Yes.
1 करोड़ तो
The
2020 में हुआ।
right, ये 19 का है.
हम्म,
The NCLT Cuttack bench admitted the Section 7 application on 4th of June 19, leading to the initiation of CRP. A plan submitted by Regus Impacts Private Limited was approved by the NCLT on 22nd December 21. Appeal. The HIW Workers Union filed appeal against NCLT approval of the resolution by raising concern about the legitimacy of the loan, constitution of the COC, and the inclusion of related parties. Okay. Issues involved were whether the loan claimed by the Nandakini Contractors Private Limited qualifies as financial debt under IBC, appropriate for initiating CIRP against the corporate debtor. Whether the admission of Section 7 application and the initiation of CRP were in accordance with the legal requirements and provision of the IBC.
हम्म,
Whether the inclusion of related parties in the COC vitiated its constitution and the resolution passed in its meetings. Whether the action taken by the RP were in accordance with the provision of the IBC and free from allegations of prejudice and party partisanship.
partisanship।
Okay. Whether Regus Impacts Private Limited was disqualified from submitting a plan for the cooperator. These were the questions.
हम्म,
Brief of cases that the case pertains to CRP of HIWL, which see a successful closure with the approval of the plan of the successful bidder Regus Impacts by Cuttack bench of NCLT on 22nd December 22. The HIW was owned by the Infrastructure Development Company IDCOL of the Government of Odisha. ये सब्सिडरी थी शायद, आई थिंक, हीराकुंड.
हम्म,
द
तो
गवर्नमेंट
गवर्नमेंट ने अपना डिसइन्वेस्टमेंट कर दिया इसमें।
The
इसमें
government
3
of
कंपनी आ
Odisha
गई हैं।
divested from the company and 100% of its shareholding was offered to 3 companies: Varsha Fabrics, Mudrika Commercials, and India Finance Private Limited. यहाँ पे लिमिटेड डालना होगा.
हाँ,
Thereafter, on direction of the High Court of Odisha, a tri-party agreement should be entered into between the HIW Workers Union, IDCOL, and the 3 companies to ensure disbursement of pending dues to the workmen.
एक्चुअली वर्कमैन के ड्यूज पेंडिंग थे, तो उन्होंने कहा भाई ये 3 कंपनियां हैं, तो आपस में ट्राइपार्टाइट एग्रीमेंट कर लो।
Hmm. In 2007, the HIWL shuts its factory at Hirakund, and the same year, 3 companies owing to HIWL transferred their entire shareholding to a company called Indo Wagon Limited, but the worksmen due still remain unpaid. Thereafter, the workers moved High Court, which directed the Labour Commissioner to sell asset of the company to recover the worker dues. Later in 2016, on the order of Supreme Court, the Sambalpur Labour Court determined that the compensation payable at rupees 45.66 crore and ordered SIWL to pay the workers due within 3 months. However, the 3 companies failed to make the necessary payment. Thereafter, the Odisha High Court ordered re-auctioning of the asset of the company for payment of workers' dues. Hindalco Industries was the lone bidder in the auction. However, just one day after the High Court of Odisha passed order on 8th of April 19 directing auction of the asset of the cooperator for discharging worker dues, financial creditor Nandakini contractor insolvency application was taken up for hearing by the Cuttack bench of NCLT. The financial creditor and cooperator made a joint request for urgent hearing मतलब दोनों ने मतलब साथ में किया, द एफसीए एंड सीडी मेड अ जॉइंट
हाँ
फॉर
हाँ,
अर्जेंट
ये
हियरिंग ऑफ
सब
सेक्शन
मिले हुए थे
7
आपस में, एक्चुअली आरपी भी मिला हुआ था इसमें।
on 3rd June 19 and it was heard on 4th June 19, leading to passing of the order admission of section 7। मतलब एक दिन में ही पास हो गया।
हाँ
And declaration of initiation of CIRP by financial creditors soon thereafter. Soon moratorium was imposed under the IBC regarding the asset of the cooperator, and Anandra Korada was appointed as the IRP, who was later retained as the RP also.
हम्म,
Once the moratorium was imposed, Hindalco Industries sought the copy of the detailed expression of interest. However, the resolution professor rejected the request from Hindalco Industries, and while Hindalco was seeking legal recourse against the rejection of RP to share the detail of UI, the resolution professional filed application under section 31 of the IBC seeking of approval of plan submitted by the SRA Regus Impex, and such approval was granted by the एजुकेटिंग अथॉरिटी। मतलब वो बहुत जल्दी जल्दी सब काम हो
हाँ
गया।
हाँ
The RP could not even produce sufficient proof of financial transaction between the financial creditors, Nandakini contractors, and cooperator Hirakund Industries work. That the time when Hindalco gathered information about the member in the COC and the found that many of them were related party of the cooperator Hirakund Industrial Work Limited and therefore were ineligible to be part of the COC. And while Hindalco and the worker unions sought intervention from the NCLT, it heard the application for approval of the plan by Regus Impacts, the SRA, and approved it by order dated 22nd December 21. Hindalco moved NCLET and sought its intervention in the matter. It questioned the allegedly default payment by SIWL on financial loan of Nandakini contractors. It also questioned the legal sanctity of the process through which the CRP was initiated. It also claimed that the financial creditor, including one of the initiated the CRP and the successful applicant, are also linked to the cooperator, and thereafter tried to establish that the whole CRP process was stage managed and fraudulently done. The NCLET concurred with all the allegation of Hindalco. The NCLET was agreed to the appellant Hindalco. The appellate tribunal in its order said that it is convinced that Section 7 application was submitted by Nandakini contractors fraudulently in collusion with the cooperator to seek an admission of order of CRP of the cooperator, and such an admission of order was given by the educating authority without proper and adequate scrutiny of the contents of the Section 7 application, without examination of material therein. It also accepted the fact that the companies belonging to the same group of companies were acting in concert to initiate and
परपेट्रेट।
perpetrate the fraudulent CIRP. It was convinced that the senior counsel of Hindalco and SIW unions have, on the basis of documents that are in public domain regarding shareholding patterns of the stakeholder companies, their registered address and their email ID, explained the inter-cited web of interconnection between Adishwar
इंट्रिकेट वेब।
intricate web of interconnection between आदिश्वर निवेश प्राइवेट लिमिटेड, ये दूसरा कुछ कंपनी आ गया।
हाँ, ये होल्डिंग कंपनी थी ना कॉर्पोरेटर की।
ओके, होल्डिंग कंपनी तो गवर्नमेंट कंपनी थी ना कुछ, जो उड़ीसा।
नहीं वो ठीक है, बाद में तीन कंपनी आ गई ना, बाद में तीन कंपनी आ गई थी।
द होल्डिंग कंपनी ऑफ द कॉर्पोरेटर, द मेंबर ऑफ द सीओसी एंड द सक्सेसफुल आरए, द रिगस इम्पैक्ट,
ये आपस में कनेक्टेड थी।
Okay. These interconnections and cross investment have not been disputed by either of the cooperator or the SRA. It is quite clear that these companies are being guided by a controlling mind and were acting in concert to defeat the objective of the IBC. मतलब वो डिले करना, डिफर्ड करना चाहते, जो पेमेंट था
नहीं
45
वो ये कि सारे आपस में मिले हुए थे। ये जो कंपनी थी और ये जो सक्सेसफुल रेजोल्यूशन एप्लीकेंट था, ये रिलेटेड पार्टीज थी।
हाँ, ये जो कोलिजन हुआ है,
हाँ
ये मतलब ये ओनली विद द मोटिव दैट ये जो 45 करोड़ का जो
हाँ,
पेमेंट है
बस ये ना देना पड़े। यस,
ये इसके लिए इन्होंने ऐसी, जो मोरेटोरियम में आ जाएगा तो क्लेम
हाँ
फाइल
बस
हो
बस बस
जाएगा,
यही।
फिर ऑपरेशनल क्रेडिटर में आएगा तो उनको कुछ देना नहीं होगा।
हाँ हाँ
The court further said that in order that this glaring instance of related parties of the cooperator becoming member of the COC is sufficient to make the constitution of COC illegal and render all the decision and resolution adopted in COC meeting with the participation and voting of the four companies referred above null and void in the eyes of the law. On the issue of whether the SRA Regus Impacts was disqualified to submit a plan, the court noted that the Isha Trader and Looney Housing and Developers both are 50% shareholder of the SRA. Now, Sheetal Exports has 31.60% shareholding in the Isha Trader, and Sheetal Export also has a 15.8% shareholding in Adishwar Nivesh, which hold 99% shareholder in the Indo Wagon, which is the holding company of the corporator. मतलब बहुत सारे कंपनीज का
हाँ,
कनेक्शन,
इन्होंने ना पूरा चार्ट दिया उसमें सबमिशन में अपनी कि देखो कैसे इंटरकनेक्टेड है।
मतलब कौन SRA से कनेक्टेड है, कौन
हाँ,
RH से
बिल्कुल
कनेक्टेड,
बिल्कुल।
ये CD से कनेक्टेड है।
हम्म,
तो जो COC मेंबर्स है वो भी कनेक्टेड थे,
हाँ हाँ।
तो उनका सारा चार्ट दिया होगा मे बी।
हम्म
Additionally, Divya Mercantile and Fragment Nivesh are holding 1.74% and 1.05 shares in Daisha Traders, are also shareholder to the extent 28.45% and 17.55% respectively in Adishwa Nivesh, thereby exerting an influence which is in infringement of the clause K and M of section 524 of the IBC.
हम्म
5 is for which defines the financial getter, right? Section 5
रिलेटेड पार्टीज है ना।
Okay.
यस प्लीज।
The linkage between the cooperator Hirakund and Regus Impacts is quite apparent, which has been brought out in the charts submitted by the applicant HIL, which is included in this judgment. The court noted on the role of the resolution professional Anandrao Korada, which the court said the RP did not make any meaningful attempt to even inquire into allegation of fraud, collusion, involvement of related parties, and interrelationship between all entities involved in the CIRP. It pointed out that the first and foremost striking instance of the act of omission by the RP is displayed when the Educating Authority wide order dated February 20 directed the RP to produce before the Educating Authority the financial debt and proof of such debts. We earlier noted that the RP failed to do so despite being reminded by the Educating Authority. When we find that the purported debts and the proof of debts of the financial creditor, including in the COC, are not established appropriately, the responsibility of the RP becomes very clear. The court also noted that the RP Anandra Korada puts his signature on affidavit made in the name of Director Sujit Datta Roy regarding the SRA not being the related party and thereafter not ineligible under section 29A of the IBC to submit a plan. मतलब यहाँ पे भी धोखा किया था, लफड़ा किया था. The NCLAT set aside the admission of order of NCLT, which would lead to all the other action, including CRP, as non-est and null and void. Therefore, the CRP against the cooperator will stand debated, and the cooperator will be freed from the rigors of CRP, including the effect of moratorium. The approval of plan of Regus Impacts was also quest. सब खत्म कर दिया. It also imposed a penalty of rupees 50 lakh each on Hirakund Industrial Works and financial creditor Nandakini contractors. Okay, cost भी impose किया. The payment of 40 crore made by the SRA applicant to the financial creditor in implementation of successful plan has been asked to deposit back with the SRA Regus Impacts within 1 month of the date of this order. पर सर जब रिगस भी उसमें इंक्लूड था तो उसको भी तो वहां से कुछ पैसा रख लेना चाहिए था उसका. The tribunal has also ordered investigation by the IBBI on the conduct of the resolution professional Anandra Korada. The inquiry has been asked to be completed within 3 months. Conclusion. The NCLAT set aside the NCLT's order approving the plan submitted by Regus Impacts Private Limited. The tribunal directed the COC to be reconstituted with the inclusion of without the inclusion of the related parties and order a fresh consideration of plan. This judgment underscores the importance of ensuring the legitimacy of financial debt before admitting Section 7 applications and maintaining an unbiased COC. It also highlighted the need for transparency and impartiality in the action of the professional.
यस,
ये
ये दे दिया कि कैसे रिलेटेड पार्टी थी.
ओके जो फैक्ट क्या है, द ईसर ट्रेडर्स एंड लूनी हाउसिंग एंड डेवलपर्स बोथ आर 50-50%
ये तो हमने पढ़ ही लिया. एक बार ना
हाँ.
इसको देख लेते हैं, ये चार्ट देख लेते हैं. ये पता नहीं क्यों नहीं आ रहा, आना चाहिए अभी. पेज नंबर 23. एक मिनट, मैं इसको ऐसे करके करता हूँ. ये इसमें चार्ट का लिंक है एक्चुअली. वो मैंने ऑर्डर उसका निकाला था ना, तो देख लेते हैं एक बार अगर नजर आता है तो. अच्छा, ये इसमें आ नहीं रहा. कोई बात नहीं, इसको मैं दोबारा से पोस्ट कर दूंगा. अगर आप ऑर्डर पे इस पे जाओगे ना, तो आप, मैं चार्ट देखना चाह रहा था, तो एक्चुअली चार्ट का मैंने लिंक डाला था. उस टाइम तो नजर आ रहा था ये.
आई थिंक वो हट गया होगा, कंटेंट्स में हटा
हाँ,
दिया होगा.
हो सकता है. हाँ, तो कोई बात नहीं, इसको डाल के ना एक बार ग्रुप में डाल दीजिएगा कि भाई ये है इसका, उन्होंने पूरी रिसर्च की. भाई सारे पब्लिक डोमेन में डॉक्यूमेंट रहते हैं कि कौन सी कंपनी में किस किस की शेयर होल्डिंग है. तो उन्होंने शेयर होल्डिंग से पूरा चार्ट बनाया. भाई इधर से इधर जा रहा है, इधर से इधर जा रहा है. बड़ा कॉम्प्लिकेटेड चार्ट है. तो उन्होंने ये एस्टेब्लिश कर लिया सब रिलेटेड पार्टीज. पेज नंबर 24 है ऑर्डर का. यस.
This is the case with regards to Asoka High-Tech Builders Private Limited versus Sanjay Kundra and others. The case of Asoka High-Tech Builders Private Limited versus Sanjay Kundra and others uh, address the classification of landowners as a financial creditor under the IBC. Okay. The Asoka High-Tech Builders Private Limited, the appellant, entered into a joint development agreement with JSM DevCons Private Limited, the cooperator, to develop the real estate project. Under this agreement, Asoka High-Tech, as the landowner, was to provide land, while JSM DevCons was responsible for the construction and obtaining necessary approvals. Work contract था. During the CIRP of JSM DevCons, Asoka High-Tech submitted a claim asserting itself as a financial creditor based on the JDA, Joint Development Agreement. Initially, the RP included Asoka High-Tech in the Committee of Creditors. However, home buyers challenged this inclusion, leading to the National Company Law Tribunal Indore bench directing the exclusion of Asoka High-Tech from the COC, stating that it did not qualify as a financial creditor because it owned the land only.
जॉइंट डेवलपमेंट एग्रीमेंट था ना एक्चुअली.
तो उसने पैसा नहीं दिया था, बस ओनली आई थिंक उसने लैंड प्रोवाइड किया था.
हाँ, लैंड लैंड.
So next, the NCLAT judgment. Asoka High-Tech appealed the NCLT decision to NCLAT. The NCLAT upheld the NCLT orders, providing the following rationales. No distribution of time value of money. The NCLAT emphasized that the claim of to qualify as a financial debt under the Section 5, Section 8 of the IBC, there must be a disbursal of funds against the consideration of for the time value of money. In this case, the Asoka High-Tech, as the landowner, did not disburse any fund to the corporate debtor. The tribunal oversees observed that the JDA was a contract for the development of land, where the landowner provided land in exchange for a share in the development property. Such arrangements do not constitute financial transaction involving loan or advances. The NCLAT referred the Supreme Court judgment in Pioneer Urban Land and Infrastructure Limited versus Union of India, which clarified the distinction between the financial creditor and other stakeholder in real estate projects. Significance. The judgment reinforced the principle that landowners entering into development agreements where they contribute land in exchange for a share in development property do not qualify as a financial creditor under the IBC. Consequently, they are not entitled to be part of the COC during the CS. कोई पैसा नहीं दिया था तो इसलिए
हाँ
next case is Yamuna Expressway Industrial Development Authority versus Monitoring Committee of JP Infratech Limited through Anuj Jain, Secretary and others. In this case, the CRP of the corporate, there is a JP Infrastructure Resolution Plan was approved, but the appellant YEIDA, the Yamuna Expressway, the corporate debtor, ये YDA was the corporate debtor, right?
यही यमुना एक्सप्रेस वे इंडस्ट्रियल डेवलपमेंट अथॉरिटी। एक्चुअली इन्होंने लैंड दी थी ना। होता क्या है कि समटाइम्स यू हैव टू पे एडिशनल कंपनसेशन टू द फार्मर्स।
Okay.
सो दिस इज द क्वेश्चन कि जो एडिशनल कंपनसेशन है उसका क्या होगा।
Okay, so where in the CRP of the cooperator, that is JP Resolution Plan was approved, but the appellant YEIDA was denied additional compensation paid to farmers. Resolution Plan for JP Infrastructure was to be upheld, but it was directed that 79% of additional farmers compensation to be paid to the YEIDA on par with the other secured creditors.
अब बात यह है
YEIDA
कि जो कंपनसेशन जो फार्मर्स को दे दिया वो किसको मिलेगा, इसको मिलेगा या यमुना को मिलेगा। भाई
Okay.
लैंड तो यमुना की थी, यमुना एक्सप्रेसवे वालों की थी।
The YEIDA established under the Uttar Pradesh Industrial Area Development Act 1976 entered into concession agreement with the Jayaprakash Associate Limited in 2003 for the construction of Yamuna Expressway. This agreement was later assigned to JIL in 2007. JIL is JP Infratech Limited. Under the agreement, JIL was responsible for the subcontract हो गया जो मेन
हाँ
कॉन्ट्रैक्टर
बिल्कुल असाइनमेंट कर दिया। हाँ
assignment. Under the agreement, JL was responsible for bearing all costs relating to the land acquisition and development. Following judgment by the Allahabad High Court and the Supreme Court, which mandated an additional compensation of 64.7% to the farmers for land acquisition, the Uttar Pradesh government issued a policy in 2014 to implement this compensation. The YEIDA in turn demanded this additional compensation from JIL, leading to dispute and arbitration proceedings.
भाई इन्होंने कहा ये पैसा हमें दो, ये तो पैसा हमारा है।
Okay. Legal proceedings में in 17 JIL entered CRP under the CRP code. JP Infrastructure CRP में गया है. The YED submitted a claim of 6,111.59 crores, which included rupees 1,689 crore toward the additional farmers' compensation. Initially, this claim was not admitted by the IRP on ground that it was under arbitration. YEIDA contended that under Section 13 or 13A of the 1970s Act, any amount payable to the authority constitutes a charge over the property, making YEIDA a secured operational creditor. The judgment of NCLT. On May 14, 2014, the National NCLT held that YDA qualifies as secured operational creditor concerning the rupees 1,689 crores for additional farmer compensation under the approved plan by the Suraksha Realty Limited. Financial creditor were to receive 79% of their secured dues. The NCLT directed that YIDA should receive an equivalent percentage for its secured operational claims.
इन्होंने कहा भाई ये जो यमुना एक्सप्रेसवे है दिस इज ऑल्सो ए सिक्योर्ड क्रेडिटर। तो अगर आप सुरक्षा रियलिटी को दे रहे हो, जो सुरक्षा रियलिटी कौन था, सक्सेसफुल रेजोल्यूशन एप्लीकेशन, इफ दे आर पेइंग टू फाइनेंशियल क्रेडिटर 79% ऑफ देयर सिक्योर्ड ड्यूज, तो दिस इज ऑल्सो ए सिक्योर्ड क्रेडिटर। इसको भी जो 79% दो, किसका, 1689 का। दिस वाज द इशू।
दैट पर्सन वाज जो 6000 में था उसमें 1600 सिक्योर्ड क्रेडिटर था, मतलब सिक्योर्ड ऑपरेशनल क्रेडिटर। Significance of this case. This judgment underscores the recognition of statutory authorities like YEIDA as a secured operational creditor when their claims are backed by statutory charges over the debtor's property. It also highlighted the necessity of resolution plan to equitably address the claims of all secured creditors, irrespective of their classification as financial or operational creditor.
देखिए ऐसा होता है कई बार हमारे माइंड में क्या आता है, हम क्या सोचते हैं कि सिक्योर्ड क्रेडिटर कैन ओनली बी ए फाइनेंशियल क्रेडिटर। ऐसा नहीं है। Even an operational creditor could be a secured creditor. ये issue है.
The question is that whether claim submitted by YDA in CRP of cooperator needed to be considered. The government order dated 29th of August 14 was challenged before Allahabad High Court by means of writ petitions. On one of the writ petition was also filed by the cooperator. The judgment of the Allahabad High Court facing the government order dated 29th of August 14 has been set aside by the Supreme Court in appeal filed by the appellant, that is Yamuna Expressway Industrial Development Authority versus Shakuntala Education Welfare Society 2022. This is the case number. ये कुछ केस का दूसरा रेफरेंस है, आई थिंक सो.
हाँ.
Thus, the claim submitted by YEDA in CRP of the cooperator of 1,689 crore needed to be considered in the CRP, and IRP clearly error in the disregard the claim on the ground of pending litigations. Whether a YDA is secured creditor of the cooperator, the Uttar Pradesh Industrial Area Development Act 1970 has been enacted to provide for the constitution of any authority for the development of certain areas in the state into the industrial and urban township and for matters connected therewith. Under the aforesaid act by the notification issued under Section 3, the appellant authority was constituted. The function of the authority as per Section 6 of the Act are to acquire land in the industrial development area by agreement or proceeding under the Land Acquisition Act 1894 for the purpose of development of the industrial development area. Section 13 of 1976 Act refers to any consideration of money installment thereof. Any amount due on account of transfer of any site and building of the authority admittedly by the concession agreement. ये ambiguously होगा या सर admittedly क्या है ये? This word.
कहाँ पर?
Last para, second line. Admittedly क्या है?
Admittedly by the concession agreement dated 7 February 2003, land and comprised in the lease deed was transferred on lease as per the concession agreement in favor of the concessionaire. Thus, the amount payable consequent to transfer is fully covered by Section 13.
Yes, so this was the case. Yes, please. Next.
Mr. Anuj Bajpayee versus Employee Provident Fund Organization, EPFO, and others. In this case, Mr. Anuj Bajpayee versus EPFO, this addressed the classification and treatment of various components of Provident Fund dues during the liquidation process under the IBC code. The EPFO filed its claim during the CIRP, and upon the initiation of liquidation, the liquidator contested the classification of the entire claim as contribution, arguing that only the principal amount should be prioritized under Section 36, Subsection 4, Subsection A, Subsection 3 of the IBC, while interest and damages should be treated as operational debt under Section 53.
तो किसमें ये आ गया कि भाई प्रिंसिपल को इसने अलग माना? प्रिंसिपल को तो माना भाई ठीक है, इट विल नॉट फॉर्म पार्ट ऑफ द लिक्विडेशन एस्टेट, लेकिन इंटरेस्ट एंड डैमेजेस को इसने कहा सेपरेट मानेंगे हम. क्वेश्चन इसमें ये था.
The NCLAT upheld the NCLT decision affirming that entire EPFO claim is excluded from the liquidation estate. All components of the EPFO claims, including contribution, interest, damages, and associate costs, are excluded from the liquidation estate under Section 36 4A3 of the IBC.
ये था इशू.
Priority, ये Section 53 का वाला priority over liquidation waterfall. These dues are not subject to distribution mechanism outlined in Section 53 of the IBC, as they are considered trust funds held for the benefit of the employees. The case cited by NCLT referred the Supreme Court decision in Maharashtra State Cooperative Bank Limited versus Assistant Provident Fund Commissioner, which established that all the amount due from an employer under EPF Act, including interest and damages, have a first charge on the asset of the establishment. The statute dues will always be first priority. The attachment lifted, given that the liquidator had secured the claimed amount in a fixed deposit, the NCLAT directed the APFO to lift any attachment on the corporate assets and refrain from initiating separate recovery proceedings.
भाई उसने उसके अमाउंट की एफडी करा रखी थी, जो भी अमाउंट था ना ड्यू, लिक्विडेटर ने उसकी एफडी करा रखी थी कि भाई जब डिसीजन होगा तब दे देंगे ये।
ओके, उतना उस अमाउंट को उसने पार्क करके
हाँ।
रखा था. This judgment clarifies that all dues under the EPF Act comprising contributions, interest, damages, and related costs are to be treated as trust obligations and are excluded from the liquidation estate. Consequently, they are not subject to the waterfall distribution mechanism under Section 53 of the IBC.
Yes, next case.
The SVA Family Welfare Trust and others versus Ujas Energy Limited and others. Decision of COC. The fact of the case was on the decision of the COC to approve the plan which allocates a plan value for relinquishment of personal guarantee was a commercial decision which could not be allowed to be impugned at an instance of essential financial creditor, and hence NCLT erred in rejecting such plan, which did not contravene any provision of the Section 30. The fact is that the CRP was initiated against the corporate debtor by NCLT and RP was appointed. The plan were received by the RP from the resolution applicant, including the appellant. The COC of the CD approved the plan submitted by the appellant, and RP filed an application before the NCLT for approval of the same. In between, a financial creditor of the corporator filed an affidavit before the NCLT objecting the said plan, stating that it provided for extinguishment of right under the personal guarantors given in favor of B. B ने कुछ दिया था फेवर, मतलब ये B को कुछ मिला था, जो फाइनेंशियल क्रेडिटर था उसको किसी ने कॉर्पोरेट गारंटी दिया था, जो प्लान में लिखा था कि वो भी रिलिक्विश हो जाएगा. इज इट द फैक्ट? The corporate CRP initiated against the Ujas Energy Limited on September 17, 2020.
Actually, कई बार क्या होता है, what happens sometimes when a resolution applicant submits a resolution plan, he says that you release my personal guarantee also. So in lieu of your releasing my personal guarantees, I will give you an X amount. So the case is whether the COC can agree to such terms and conditions. This is the case.
Okay.
So he has given, देखिए, there are two amounts which the successful resolution applicant is giving. He is giving X amount for the company and Y amount for extinguishment or relinquishment of personal guarantee. So the question here is whether COC can agree to such a resolution plan. This is the question.
Because there could be connection between the RA and this corporate guarantors.
Yes, please. So this is the question.
The resolution plan submission. The SBA Family Welfare Trust submitted a plan which was approved by the COC with the 78.40% majority. The plan proposed a total payment of 74.81 crores, including 45 crores toward the value of the corporate data and 23.81 crores for the release of the personal guarantees.
So these were the two amounts. They separately stated कि भाई देखो अगर मेरी पर्सनल गारंटी रिलीज नहीं करोगे तो आई विल पे यू 40 लाख 45 lakhs 45 crores. If you release the personal guarantees also, I can pay you 74.81. This was
मतलब सर ये जो आरए था उसने प्रपोज किया कि ये 23.81 करोड़ देगा और जो पर्सनल गारंटर से
हाँ वो भी रिलीज करो. यस,
मतलब जो सीडी के जो गारंटर्स है.
हाँ बिल्कुल बिल्कुल.
वो ऐसा क्यों करेगा, मतलब वाई?
भाई वो पर्सनल गारंटर उसी के थे ना, रेजोल्यूशन एप्लीकेंट के ही थे ना.
मिली भगत है यहाँ पे भी.
हाँ,
बैंक ऑफ
मिली भगत
बड़ौदा.
नहीं है, मिली भगत नहीं है भाई. सीओसी को डिसाइड करना है. वो तो क्लियरली बोल रहा है ना कि भाई मेरी पर्सनल गारंटीज भी रिलीज करो तो मैं इतने पैसे उसके दे दूंगा.
ओके. The Bank of Baroda holding 5.83% voting share objected the plan clause is extinguishing personal guarantee, arguing it infringed upon their rights as a secure creditors. The NCLT decision, the NCLT Indore bench rejected the plan, stating that the COC cannot extinguish the right of a secure creditor to proceed against a personal guarantor, as it contravenes section 30 subsection 2 subsection E of the IBC.
तो एनसीएलटी ने कह दिया, रिजेक्ट कर दिया रेजोल्यूशन प्लान, देन मैटर वेंट टू एनसीएलएटी।
इसमें कुछ और सुप्रीम कोर्ट का मैटर दिया हुआ है।
नहीं नहीं, वो इसी से रिलेटेड है।
तो सुप्रीम कोर्ट इन द ललित कुमार जैन वर्सेस यूनियन बैंक ऑफ इंडिया रिलेटेड केस है
वो
इसमें।
ऐसे एक्चुअली एनक्लैट अपनी जजमेंट में इस सुप्रीम कोर्ट जजमेंट को कोट किया ना।
Okay, they held that the sanction of a resolution plan does not per se operate as a discharge of the guarantor's liability. It was held that the approval of a plan does not ipso facto discharge a personal guarantor. The use of expression per se and ipso facto clearly indicate that by approval of plan, personal guarantors are not per se and ipso facto discharged from its obligation, which may arise of the guarantee given to the financial creditor. The use of above expression conversely indicates that there may be situation and circumstances, for example, relevant clauses in the plan by which personal guarantors may be discharged, the judgment of the original plan which personal guarantors may be discharged. The judgment of the Supreme Court in Lalit Kumar Jain case versus case Supra cannot be read to mean as laying down law that personal guarantors never can be discharged in a plan,
हाँ,
resolution
तो
plan.
एनक्लैट ने जजमेंट दिया कि ऐसा नहीं है कि डिस्चार्ज हो ही नहीं सकते, नॉर्मली डिस्चार्ज नहीं होते हैं।
Okay.
यस।
It is further relevant to notice that each financial creditor has personal guarantee in their favor to secure the loan extended by them. All financial creditor has assented for the relinquishment for such security except B, Bank of Baroda. We said only 5.83% of vote share. The decision of the COC to accept the value of relinquishment of personal guarantor was commercial decision of the COC, which cannot be allowed to be imposed under the instance of dissenting financial creditor.
तो उन्होंने कहा भाई सीओसी का डिसीजन है, सारे सबके पास पर्सनल गारंटीज हैं, सारे एग्रीड है इसके लिए।
सर 23 करोड़ आ रहा है तो क्या बुराई भी नहीं है।
हाँ बिल्कुल बिल्कुल, यस।
Unclear judgment. The SBI Family Welfare Trust appealed to the NCLT decisions. Commercial wisdom COC. The NCLT emphasized that the commercial decision of COC, especially those made with the significant majority, should be given due differences. Should be given
डिफरेंस मतलब रिस्पेक्ट है किस्म से।
difference. Okay. The traveler noted that the plan did not unilaterally extinguish personal guarantees, but proposed their release in exchange for a specific payment, which was deliberated upon and approved by the COC.
अब उन्होंने कहा भाई उसके पैसे मिल रहे हैं ना, ऐसे फ्री फंड में तो नहीं डिस्चार्ज किया ना, फ्री फंड में कर देता तो दिक्कत थी।
आप उसमें भी IRP उसमें भी जाओगे तो वहां भी तो कॉस्ट लगेगा ही, कितना रिलीज होगा कि नहीं, यहाँ पे स्टेट दिख रहा है। So, precedent consider the NCLT referred to various Supreme Court judgments, including Lalit Kumar Jain versus Union of India, to highlight that the approval of plan does not automatically discharge personal guarantors unless explicitly stated. Distinction from other cases. The tribunal distinguishes this case from other where personal guarantor assets were included in the plan without due process. The NCL मतलब मोस्ट ऑफ द केसेस में क्या होता है कि वो लिख तो देते हैं कि ये भी रिलिंक्विश हो जाएगा, बट विद उसमें कुछ पैसा नहीं देते उसके बदले, बट यहाँ पे पैसा मिल रहा था। The NCLT set aside the NCLT order holding that the resolution plan did not contravene section 30 subsection 2 subsection E of the IBC. It directed the NCLT to reconsider the approval of the resolution plan within 3 months. Significance. This judgment underscores the importance of the COC commercial decision in the CIRP and clarifies that personal guarantors can be addressed within a plan provided there is adequate consideration and majority approval. It is also delineates the boundaries of judicial intervention in the commercial decision of the COC.
तो ये था, तो इन्होंने कहा भाई अगर सीओसी डिसाइड कर रही है तो ठीक है, कर सकती है सीओसी डिसाइड। चलिए, तो ये हमारे हो गए खत्म। अब आ गए एनसीएलटी केसेस, फटाफट कर लेते हैं, ज्यादा नहीं है, थोड़े से ही, आज खत्म हो जाएंगे ये फिर केसेस। हाँ जी,
In the matter, this is NCLT matter.
हाँ एनसीएलटी, हाँ जी, लास्ट चल रहा है।
In this matter of Aircel Limited, this
तो
is
ये तो
matter of
वैसे
Aircel
बहुत ही
Limited.
आसान, मैं करवा देता हूँ जल्दी जल्दी। इसमें क्या है,
जी
इन द मैटर ऑफ एयरसेल लिमिटेड, सो एक्चुअली द इशू इन्वॉल्व हियर इज इट परटेन्स टू सेक्शन 14, ये सेक्शन 14 के ऊपर जजमेंट है। सो वेदर टेलीकॉम लाइसेंसेस एंड ग्रांट ऑफ स्पेक्ट्रम दे कम अंडर सप्लाई ऑफ essential goods or services, this was one issue. Then to declare that moratorium applies to all licenses including telecom licenses, then Department of Telecom be directed not to take any action against the company. So the question here is, suppose a company is not able to pay the license fees, then whether the spectrum license can be cancelled during moratorium. This is the issue. So they said they cannot terminate the license because it will affect the going concern status. So long as the current dues are being paid, so then they can not terminate or suspend the license so long as current dues are being paid. And it was only after this case that there was an amendment to section 14. अगर हम सेक्शन 14 भी खोल लेते हैं इसके साथ में, सेक्शन 14 क्या बोलता है? सेक्शन 14 में there came an explanation, and this explanation came in 28th December 2019. So this was subsequent to this case only, that because of this case this amendment came. So an explanation was inserted in section 14(1) for the purpose of this subsection it is thereby clarified that notwithstanding anything, license, permit, registration shall not be suspended or terminated on the ground of insolvency, subject to the condition that there is no default in payment of current dues. तो ये जो explanation आया, it came because of this case only. So they said, so long as they are paying the current dues, you cannot terminate or suspend the license because it will affect the going concern status. ठीक है? तो विदाउट लाइसेंस बोलेगा इस कंपनी को खरीदेगा कौन? तो विदाउट लाइसेंस दिस कंपनी शैल बी एज गुड एज अ शेल कंपनी, एंड विदाउट सच एन एसेट नो पार्टी शैल टेक इंटरेस्ट इन एक्वायरिंग दिस डेटर कंपनी. So preamble to the code, it is prescribed to maximize the asset, है ना? And DOT instructed not to cancel the license. This was the case in the matter of Jet Airways. So here the case was whether any non-core assets can be sold during CIRP period. So here the RP made a distinction between the core assets and non-core assets. So HDFC was having security over the assets, and HDFC also concurred to this. So they sold a building actually. So applicant is hereby permitted to sell the premises for utilizing the proceeds of the sale of third and fourth floor to settle the claims of HDFC at 360 crores. So HDFC gave up the security interest, charge or any other right in respect to the premises. So here the basic question is whether during CIRP you can sell the assets of the company. So this was the case where NCLT held that you can sell the assets of the company during CIRP period also. Okay? Because the idea is maximization of the assets of the corporate debtor. This was the case. So conclusion is, it underscores the challenges in reviving large companies, especially in sectors like aviation that are heavily regulated and capital intensive. The case highlights the importance of timely resolution and the need for robust mechanism to handle cross-border insolvency issues. Because they had to pay some money. In the matter of Videocon industries, so here this is a case on group insolvency, because sometimes what businessmen do, they float various companies like Videocon Group, it was manufacturing televisions. So picture tubes were being manufactured in a separate company, and screens were being manufactured in separate company. So the question here came whether individual insolvency should be resorted to or group insolvency. So this is the case on group insolvency. They said instead of initiating CIRP against a particular company, you initiate group insolvency so that somebody can take up the entire group, because the various activities and individually the companies may not fetch much value. This was the case. So substantial consolidation. Because the operations were interlinked, recognizing the interlinked operations and financial entanglements, Videocon group companies ordered the consolidation of CIRP for 13 group companies. Okay? This was the case. Next is JP Infratech. So here, this Suraksha Realty, it was the successful resolution applicant. Okay? Now, what were the objections which were put? ICICI raised an objection. ICICI Bank, a dissenting financial creditor, it challenged the resolution plan on the ground of unfair treatment compared to other creditors. However, the NCLT dismissed the objection, stating that the plan met the requirement of IBC and treated all creditors equitably. Then Yamuna Expressway. Yamuna Expressway Industrial Development Authority, there is concerns regarding land allocations and dues. So NCLT addressed these concerns, ensuring that the resolution plan complied with regulatory requirements and protected the interests of all stakeholders. Then what was the judgment? The present petition is filed under Section 7, read with Rule 4, to initiate CIRP on such ground that the corporate debtor company JP Infratech commits default in making payment of their maturity amount of fixed deposits, even after maturity periods, and due date of payment has now become due. Total outstanding amount on the petitioner's FDs is stated to be 85,79,105, including interest. The petitioners who made their fixed deposits with respondent CD claim their status as that of a financial creditor for the purpose of proceeding. So this case set a precedent in the treatment of home buyers in insolvency proceedings, emphasizing their rights and ensuring the completion of housing projects. It also highlighted the complexities involved in large-scale real estate insolvencies and the importance of balancing the interest of various stakeholders. Inquest Fintech versus Maya Gupta, liquidator of Rain Automotive India Private Limited. So this case, it addresses the critical issues concerning the assignment of not readily realizable assets, because sometimes certain assets may not be readily saleable. So if such assets are assigned, then what will be the fate? Rain Automotive India Private Limited, it was admitted into liquidation, and Maya Gupta was appointed as the liquidator. During liquidation, the liquidator identified certain assets as not readily realizable assets, including claims arising from avoidance applications. Because sometimes in avoidance applications also, there are some not readily realizable assets, NRRA, okay, which pertain to PUFE transactions. Inquest Fintech Private Limited entered into a deed of assignment with the liquidator, acquiring these NRRA for a consideration of 50,000. So these assets were assigned to Inquest Fintech for a paltry sum of 50,000. Subsequently, Inquest Fintech filed applications seeking to substitute the liquidator in pending avoidance application. Now, this Inquest Fintech said that we will proceed for these PUFE transactions instead of the liquidator. Okay? Asserting rights to pursue and recover the assigned claim. Inquest said that since we have been assigned this NRRA, so we should be allowed to pursue these PUFE applications. So what were the issues involved? NCLT examined whether NRRAs, particularly those underlying pending avoidance applications, could be assigned before adjudication. This was one issue. And tribunal considered whether an assignee like Inquest Fintech could pursue PUFE applications which were initially filed by the liquidator, given that such applications are statutorily to be initiated by the RP or liquidator. Then valuation concerns were also there. So tribunal synchronized the assignment of claims valued at approximately 26.38 crores for a nominal amount of 50,000, raising questions about the fairness and transparency of the transaction. So what was the NCLT's finding? NCLT held that while Regulation 37A permits the assignment of NRRA, Such assignment should occur post adjudication when the claims are crystallized. Assigning claims before adjudication could lead to undervaluation and potential loss to stakeholders. Then who can pursue the avoidance applications? So the tribunal emphasized that PUFA applications can be filed and pursued only by the RP or liquidator. An assignee does not have the statutory authority to substitute the liquidator in these applications. Then apprehension over valuation. NCLT expressed concern over the significant disparity between the value of claims and the consideration received, suggesting that such transaction could be detrimental to the interest of creditors and other stakeholders. So NCLT dismissed Inquest Fintech's application, reinforcing that assignment of NRRA should be conducted transparently and post adjudication to ensure accurate valuation. Only the RP or liquidator has the locus standi to initiate and pursue avoidance applications, and transactions that potentially compromise stakeholders' interest due to undervaluation are subject to scrutiny and may be set aside. So this was the judgment. Parveen R. Navandar, RP of VOVL versus BPRL Ventures, BV. So what is the case here? So VOVL is a subsidiary of the Videocon Group. It held a 50% stake in IBV Brazil Petróleo Limited, IBV, a joint venture between BPRL Ventures, a wholly owned subsidiary of Bharat Petroleum. The joint venture owned oil and gas assets in Brazil. So what was the development? Offer by BPRL. BPRL exercised its right of first refusal to acquire VOVL's 50% stake in IBV. The Committee of Creditors approved BPRL's offer in its 40th meeting. So what was the conclusion? The conclusion was NCLT's decisions facilitated the resolution of VOVL's insolvency by approving the sale of its stake in IBV to BPRL and initiating the liquidation of its remaining assets. The case underscores the importance ये कहाँ चला गया? So the case underscored the importance of adhering to procedural requirements under the IBC and the role of the COC in approving significant transactions during insolvency proceeding. So here the case is that suppose a company is owned by two people. So whether one person can sell its stake to the other company. This is the case, basically. So this was the last, and with this we complete the entire judgments.